Less controversial, of course, is the gay marriage initiative, Prop 8. This is the entire initiative, basically, right here. It would add this sentence to the state constitution. Prop 8, as you know, just to give a little chronology here, in 2000, in response to some other states, most notably Vermont, passing civil union legislation, voters in many states voted on preventing the recognition of gay marriages that were legalized in other states. Kind of ironic that California is now the focal point of all that. But we passed Prop 22 by about 61% of the vote in March of 2000. It was a presidential primary. It was a fairly contested one. Voter turnout was decent. And the thing about it was it was a statute. It was not a constitutional amendment. They didn't collect enough signatures to qualify as a constitutional amendment. In 2003, when Governor Davis was being recalled, the interests that are in favor of gay marriage in California put a piece of legislation through the legislature that created civil unions. And I mean, there's a debate right now over whether people in civil unions have all the rights of being married or not. And that's part of the conversation in this initiative. But substantively gave them most, if not all, of the privileges of being married. I mean, the language actually says that you have all the rights and privileges of a spouse. But then there are other parts of the California Code where they haven't changed the language, and so there's some ambiguity. In February 2004, so this was passed by Governor Davis in the middle of the recall, and nobody noticed. It went completely under the radar screen. There was no effort to repeal this. In 2004, Gavin Newsom had his famous, "I don't care what the law says, I'm going to vote, I'm going to marry people." And until a judge shut them down and said, "Don't do it anymore." Interestingly enough, it was this instance where the court shut them down that created the lawsuit that led to the decision last May by the Supreme Court that basically said, because homosexuality is a protected civil category in California, that the Equal Protection Clause must allow all privileges that go to heterosexual couples to go to homosexual couples. And that was the basis of their decision. Immediately, there was an effort to qualify an initiative to repeal this. And on June 17th, there was actually a lawsuit to try and delay the initiation of gay marriages until after the vote in November. The court said, "No, thank you." And so they authorized gay marriages to begin on June 17th. So everything I'm going to say is for gay marriages that would happen after this initiative passes and is recorded into the state register. We don't know what happens to those marriages if this passes that were held between June 17th and November 4th. But, as you can imagine, there are two huge debates on this. One is that marriage is a special institution, a unique institution that needs to be protected. There is a debate over if you allow sort of any definition of marriage to be added to it, what prevents you from then adding other definitions? And there's all kinds of absurd examples given. But there's a practical perspective. I mean, one of the reasons why Utah's admission to the Union was delayed was because of bigamy. And so if you start redefining the marriage relationship, whether you could in fact allow bigamy, for example, as another judgment by the courts, once you make this a civil institution, you start raising those questions. I'm not saying it's founded or not. The court overstepped its bounds. Clearly, the voters expressed one opinion in 2000. The argument is that the court created a right that wasn't there, but because it was a statute, it has no binding on the Constitution. This is a constitutional amendment, so it would be binding. Whether the court reverses itself or not, still left to be seen. Can undermine California society. It does not reverse the rights of gay people in civil unions. It leaves civil unions intact. The other argument, and you've seen the commercial, I'm sure, it's been on every 30 seconds, that says that in fact, because these are acknowledged, recognized marriage institutions, that schools, to the extent they teach positive family models, have to teach gay marriage as a positive family model. The arguments against it, obviously, marriage is a civil right. We shouldn't treat any one person any differently than anybody else. Gay marriage doesn't affect heterosexual marriage in any way. It doesn't come at any cost. There's no externality directly to those people. This is a quote from one of their campaign leaders. Government should not tell us who to marry any more than it should tell us what to watch on TV. It's basically unfair to preclude gay marriage. And again, one of the arguments is, well, what about these marriages that have already been performed? Does that mean only people who got married between June and November get sanctioned by the state and everybody else has to go away? This has national consequences, but since it's a state initiative, because other states are dealing with the reciprocity and recognition of marriage in California. Any questions on this one? All right, setting legislative priorities. We're coming back to Prop 6 now, which is another criminal justice issue. It's kind of a mishmash. George Runner, who's the sort of proponent and driver behind this, is a state senator from up by Lancaster, sort of a law and order guy. And as he served, he noticed that there were lots of issues in the legal system. So he actually does two things. One is he creates a mandatory level of spending. Most of this money gets transferred to local law enforcement agencies, but he sets a constitutional requirement. It's an initiative statute, so it's actually not constitutional, but a statutory requirement that government spend minimum levels on certain law enforcement activities. I have to watch the time, the clock's hidden behind the screen. But that you spend a minimum level on certain law enforcement activities. And it's about $365 million this year increase in spending. It'd go up to about $500 million over the next 3 or 4 years, so it's a significant increase in spending. There's also a requirement that extra money be provided, especially to local jurisdictions, to expand prison facilities. And then it takes on a range of issues. This is one of those initiatives that if it were passed, the court would have to rule on whether it's in fact a legal initiative, because it covers a lot of topics. And initiatives by the state constitution have to be single issues. And so it probably would meet that standard because they're all sort of criminal justice related, but I guarantee you the lawsuit would come. It talks about extra censure and sentencing guidelines for gang participation, for methamphetamine, vehicle use, tampering with judges or witnesses, and then if you're a felon and you're caught with weapons, it also expands the penalties there. It has a whole bunch of provisions. It also requires that we expand the GPS tracking on our parolees, especially for sex offenders, so that we have a better sense of where they are. The arguments for, obviously, local law enforcement likes this idea. Ironically, the guy who put up some of the seed money to qualify this, a guy named Henry Nicholas, who was a co-founder of a company, is now being investigated for, or he's under indictment for drug violations and other charges, so he could conceivably be one of the lucky folks sentenced under something like this. The prison guards union have put money up on this, obviously, because it will expand sort of prison time and sentencing requirements for convicted felons. The folks who are opposed to this are the ones who are worried about money. So it's your teachers' unions, the community college unions, SEIU, the service employees, have all put up the money to fight this. You're going to see more on this one, I suspect, over the next few weeks, because it does mandate spending for law enforcement. And if I mandate it for law enforcement, that's less for other programs. And so that's part of why you see the competition. Any questions on this one?
So, what would happen if Prop 5 and Prop 6 were passed? So you have the one proposition that's expanding sentencing for methamphetamine use, and the other one that's taking it away.
Well, every initiative has a paragraph at the end of it, pretty much, except for Prop 8, interestingly, that says that if this and another initiative both pass and conflict with each other, the specific areas where they contradict each other, the one who has the most votes wins. And so, I mean, you see that language in almost every initiative, and especially one with this complexity. So at the end of it, it just says, if I contradict Prop 6 or Prop 5 in any specific area, and they also have what's called a severability statement that says if any one part of this gets thrown out by a judge, the rest of it remains.
So this is going to cost the state, you said, $500 million within the next 2 years?
Yeah, about $500 million.
Okay.
A year.
Is that aside from the initial 300?
Yes. No. The initial starts at about 365. It goes up to about $500 million in a couple years. Okay. There's a $500 million. I've been doing federal finance too much. There's a $500 million cost roughly for facilities up front. Okay. On top of that $365 million.